Hi, everyone. Welcome back to Year 1. I'm Miles.
And I'm Grant. And Miles, this one's got some teeth.
Oh, it does. So TechCrunch broke this on June 26th, a founder named Marc Seitz accusing an insurance startup called Corgi of lifting his open-source dataroom software.
And Corgi's own CEO turns around and admits their AI vibe-coded pages read almost word for word the same.
Wait, seriously?
Yeah, that's the defense.
And then Corgi doesn't just deny it. They send cease-and-desist letters, one over the original tweet, one over a joke tweet that had nothing to do with any of it.
Which, tends to escalate things rather than calm them down.
We're also going to stack this up against the PearAI cloning mess from 2024. See if the playbook's the same.
And whether getting sued more than once actually spooks enterprise buyers, because that math matters for a startup at Corgi size.
Plus, there's this whole culture angle. Funding rounds, 7-day work weeks, tattoo stories. We'll get into how that all connects.
Same aggressive instinct, different arenas maybe.
And here's the open question. Papermark still hasn't sued.
Yet.
So let's start with what actually happened.
Starting with Marc Seitz's side of the story. Here we go.
So Marc Seitz, Papermark's co-founder, posts screenshots on X, side by side, Papermark's dataroom software next to Corgi's brand new dataroom product. Same wording, same feature names, word for word.
Word for word is a strong claim.
That's basically what Seitz said too. He called it copyright infringing, called it fraud actually, according to TechCrunch's June 26th piece.
And Corgi's answer?
Nico Lacqua, the CEO, first says he's investigating, then he posts his own receipts showing the underlying code is different. But then he admits something. TechCrunch reports the lookalike bits were vibe-coded, AI tools spitting out near-identical text and layout on 2 settings pages.
Wait, so the code's different, but the wording's identical?
That's the defense, yeah. Lacqua's own words. That's on us.
That's not really a defense. That's an admission with extra steps.
Kind of, yeah.
Okay, here's what actually stops me. Seitz posts the screenshots. Corgi sends him a cease and desist demanding he delete the tweet. Then somebody at Hello World Cafe cracks a joke about the whole thing, and Corgi's lawyers go after him too?
That part I did not expect either, over a joke tweet.
That tells me this isn't really about the code. You don't lawyer up over a punchline unless you're already primed to fight.
There's a bigger question under all this, too. Dan Barrett, a fellow UC founder who runs OpenPros, posted about it. TechCrunch quoted him, asking what makes one unacceptable and the other not when a bot can copy the feel of a product without copying a line of code.
Which is a fair question. Existing IP law was built for humans copying humans, not a model doing it in seconds.
And nobody's answered it yet.
So if a joke tweet gets a legal letter, what happens when Papermark's actual lawyers show up?
That's before you even get into what Corgi's done to former employees.
Wait, there's more?
Building on that pattern, TechCrunch's own piece on this drops a line almost in passing. It says Corgi, quote, has already sued various former employees.
Wait, that's before Papermark even happened?
Predates it entirely. 2 years old, this company, and it's already got a reputation for being litigious. That's the word TechCrunch uses.
Okay, so former employees is one thing. Founders protect trade secrets, that happens. What's the vouch situation?
So this is the big one. Corgi's own blog, they publish this themselves, says Corgi and its underwriting partners sued Vouch Insurance and its chief legal officer in Delaware federal court.
For what exactly?
They allege Vouch's CLO, a woman named Kelly Wolf, set up a shell company called Augmenta Advisory, ran a fake application through Corgi's platform, and canceled the policy days later once she had the underwriting data.
So a shell company to go quote shopping for trade secrets.
That's the allegation, yeah. No employees, no revenue, no tax ID. Existed to get inside the platform, according to Corgi's complaint.
Okay, but Vouch's answer to this is the part that got me. They filed a motion to dismiss, and inside it, they say Corgi's own co-founder, Emily Yuan, did the identical thing to Vouch's platform in 2024, 2 years earlier. The co-founder allegedly ran the same play, probing a competitor's quote system before Corgi ever sued anybody for it? That's the framing Vouch is going for, yeah, and once you see that, you can't unsee it in the rest of the docket. Because it's not just Vouch, right? This is a company fighting on multiple fronts at once. There's also a trade secret suit against the founders of a rival called Matcha Holdings, and separately, Corgi's Beagle unit has an antitrust case going against Appfolio. 4 fights, overlapping timelines. At minimum. Okay, so here's my tactical question, and I want a real answer. Is this defensible IP protection, or is Corgi just picking fights as a growth strategy? I mean, both things happen in the same company all the time. A founder who's genuinely paranoid about IP theft can also be someone who reaches for a lawsuit before a phone call. Sure, but 4 active cases in 2 years is a lot of paranoia.
It is. And when your own co-founder allegedly did the exact move you're suing someone else for, that's not a great look for the paranoia defense.
Right. It stops being we protect our secrets and starts looking like we sue first.
Which is exactly the question worth putting to somebody who actually litigates this stuff for a living.
Because from where we're sitting, no code was copied and we had to sue Vouch sound like 2 very different defenses.
One legal, one strategic. Let's see which one holds up.
Shifting to the legal weeds for a second.
Please, I love the weeds.
So, the no code was copied line Corgi gave TechCrunch on June 26th, that's not just spin. Copyright protects the literal code, the actual expression, not the idea of a data room.
Right. Function over form. You can build the same feature, not infringe, as long as you didn't lift the file itself.
Exactly. Where it gets shaky is when the wording on the page matches close enough that independent creation stops sounding believable.
Which is a completely different fight than they've been having in public.
It is, and attorneys will tell you it's the harder one to win because you don't need to prove code theft. You just need 2 screenshots side by side.
Compare that to PearAI. Remember that one?
2024, another YC company, except their founders just admitted it, forked an open source project, barely renamed anything, got caught, and apologized.
So that's a confession. This is a denial with a strange explanation bolted on.
Which is worse, oddly. A confession you settle and move on. A denial that includes our AI happened to vibe code the same sentences creates a discovery nightmare. Every prompt log becomes evidence.
Wait, so the defense itself builds the paper trail that could sink them?
Could. That's the exposure.
Now the cease and desist over the joke tweet, is that even legally defensible?
Probably on paper. Most C&Ds are boilerplate, cheap insurance lawyers fire off fast, but reputation side attorneys will tell you the math misses something.
Right.
Courts don't care about vibes. Customers and juries do.
And once that story's out, the eventual ruling doesn't matter.
It doesn't. The damage front loads before any judge weighs in.
Okay, my actual question then, for an acquirer or enterprise buyer looking at Corgi today.
5+ lawsuits in 2 years.
Right. Real signal or noise from a company raising fast and shipping fast?
Honestly, both readings exist. Some investors will say litigation volume tracks growth, more surface area, more disputes.
Sure, but enterprise legal teams doing diligence don't read it that kindly. A repeat pattern of IP fights is exactly what gets flagged before a big contract signs.
And that flag gets pricier with every headline.
Which raises the money question. How does a company move this recklessly while raising this much this fast?
Funny you ask. The numbers behind Corgi's rounds are wild on their own. Follow the money for a second. The timeline here is wild.
Walk me through it.
According to Wikipedia's page on Corgi, they closed $108 million Series A, then $160 million Series B, then $106 million Series B1, all within months of each other.
3 rounds that fast?
3 rounds. Valuation went from around $630 million to $2.6 billion.
That's basically a rocket sled.
And right in that window, Laqua goes on Harry Stebbings' podcast talking about expecting 7-day weekdays from employees.
I remember that clip. People lost it.
It surfaced almost the same week as the Papermark mess, so now folks are reading the 2 stories together.
Right. A cease and desist over a joke tweet lands different next to that.
Exactly. Add the stories about employees getting company logo tattoos, sleeping at the office.
Which, sure, hustle culture isn't exactly new. Founders have romanticized the grind forever.
True, but stock it with the legal aggression and the picture becomes specific.
Right.
Speed is the whole operating philosophy here. Funding, product, lawsuits, same reckless clip.
So the culture stuff and the legal stuff are the same instinct?
The instinct that says raise before anyone can catch up also says sue before anyone asks questions.
That's a hell of a bit with $2.6 billion sitting in the bank.
And Papermark hasn't even filed anything yet.
Wait, nothing? Still just tweets and letters?
Still just tweets and letters, which raises the real question for whoever's in the next batch watching this. So, zooming out from the tattoos and the funding rounds, as of this recording, Papermark still hasn't filed anything.
Right. Andrew Geider's write-up from June 25th confirmed that. No lawsuit, just the C&Ds and a lot of very online arguing.
Which means everything we just talked about is still a public fight, not a legal one.
And that's what makes this such a strange test case for the next batch coming through YC.
Because the tools that let Corgi's engineers allegedly reproduce Papermark's wording overnight, every founder in this next cohort has access to those same tools.
So the real question isn't, did Corgi copy Papermark? It's what happens when copying takes an afternoon instead of a quarter.
Yeah, if AI coding makes cloning a competitor almost frictionless, does firing off cease-and-desist letters actually protect you?
Or does it just paper over a product decision you can't defend on the merits?
I've watched founders confuse aggression for strategy before. Sometimes it buys you 6 months. Sometimes it's the thing investors flag 2 years later in diligence.
Here's what I keep coming back to. Does Corgi's playbook become normal? Every AI and native startup moving at this speed, lowering up the second something looks familiar?
Or does a partner stand up at a batch dinner 2 years from now and use Corgi as the exhibit A of what not to do?
I'm curious what you all think. Shield or liability? Because right now, nobody, not Corgi, not Papermark, not YC, actually knows the answer.
And neither do we. This one's still moving.
Yeah, we'll keep watching the docket.
So, if there's one moment from this whole Corgi story that sticks with me, it's Grant's point about the cease and desist.
Yeah, the one over the joke tweet. You don't lawyer up over a punchline unless you're already primed to fight.
Right. That's the tell more than the code itself.
And it connects back to everything else. The funding climb, the office culture, all of it.
Same instinct, different arenas.
Exactly. So the real question we're leaving you with, does aggressive legal posture protect founders using AI tools, or does it just paint a bigger target?
We don't know yet. Papermark still hasn't sued.
Story for another day, maybe.
If you know a first-year YC founder with a story like this, send them to year1@heymatto.com.
And if this episode changed how you think about startups, leave us a review. It really helps.
Thanks for hanging out with us.
See you next time.